Here we have it.
Yes. One-way ticket to hell, yes.
Can we reserve judgment on whether it is or isn't a one-way ticket? I'll let you know later.
Yes, of course. The good news, my lords and my ladies, is that we're on page 17 of this. I thought it might be helpful to have the whole of it, just in case you need to check your notes, but obviously what matters is what I said orally, insofar as I've modified or departed from it, then it's the oral submissions that count. If we can pick it up on page 17 at paragraph 50, and I think really orally the only point I need to make about the further authorities that my learned friend referred to in her note of yesterday is that they don't undermine the principle that I've been putting forward, that long unlawful residency procured by voluntary incapacitous actions shouldn't impose a positive obligation to grant leave to remain. And in summary, two of these cases that she cited, Hoti and Shivonova, are cases like Mandizabal, where an applicant has built up a private life while lawfully resident in a host state. The other one, Keita, concerned someone who was stateless and irremovable through no fault of their own, not someone who had it in their hands to return if they wanted to.
Can I tell you the difficulty I have with your submission? The first sentence is that I'm not sure it's being suggested that long unlawful residence by itself should impose. But you've accepted that long unlawful residence procured by voluntary capacitous actions is a relevant factor in the balancing exercise. So what actually does this submission amount to?
Well, it amounts to submission that there's a general principle in the Article 8 case law that in general in principle there's no obligation to grant residency. I accept it's not decisive, but the fact is that the Article 8 case law strongly points against an applicant in a case like this, where it's all in their control and there's no family life. So that's all I think I need to say orally. What I've done in paragraphs 16 to 18 is set out in more detail the many distinctions that can be drawn between this case and the cases of Hoti, Shevchenova, and Keita, which are different on many levels. And I'll just pause to let you read those paragraphs rather than reading them out myself.
Yes, thank you.
So the long and the short of it, paragraph 18, is that there is no Strasbourg or domestic authority that's ever found before this upper tribunal decision that a right to respect for private life imposed an obligation, there's an obligation under Article 8 in other words, to grant leave to remain due to a private life built up in a host state when someone was residing unlawfully and unremovable through their own actions. And on the contrary, all the authorities, the Strasbourg cases like Ramadan, the domestic cases like Hamza, indicate that long unlawful residence from an applicant's voluntary decision to make removal impossible shouldn't impose a positive obligation. paragraph 19 refers to Hamza, which is cited in my skeleton argument. Paragraph 20 is a point that I think I've made orally sufficiently clearly. So if we can then move on to ground 2, and this is focused on what the upper tribunal said about deterrence. And as you see from paragraph 21 in the speaking note, we say there are 2 flaws in the upper tribunal's approach. The first flaw is looking at the wrong cohort, which is British citizens rather than recalcitrant illegal immigrants. Pausing there, the two may have rather different perspectives. If one's trying to send a message, crime doesn't pay, then the way that message is received by an ordinary member of the British public may not be the same way it's received by someone from a cohort of people who are breaking the law. So that's the first flaw. And the second flaw is that it focused too much on the particular details of AM's life rather than the message that the judgment would convey to the relevant cohort. And paragraph 22 is an example that I gave before the short adjournment of the person who, having been in the UK illegally for 18 years, without ever becoming an addict or homeless, suddenly is confronted with a situation where they're asked to provide biodata, and they have a choice. And in my submission, the 267 AD gives them an incentive to comply with the requests. This judgment weakens that incentive.
Well, he would, on your analysis, fail because he's been committing a crime by working illegally.
Well,
so it's not much of an incentive. I mean, if you're being cynically advised, you delay everything and cooperate with nothing.
Well,
and then you look at the number of removals, and it's not very high if you're being cynically advised rather than fairly advised.
I suppose there are 2 points there. That one, if they've not been convicted at any point, then having worked illegally isn't necessarily going to trigger the suitability requirements. And secondly, perhaps that's a detail I didn't need to add. There could be someone who's lived in the UK for 18 years, and there's no positive evidence one way or another how they've managed to fund themselves. You may suspect that they're working illegally, but there's no evidence to demonstrate that. So it's not a suitability requirement that can be held against them.
I mean, these are all policy matters which are not for us, but in some respects, you end up encouraging the illegal working because you can't work at all.
Well, as you say, those are policy matters which are for the executive, and I can see that perspective. But the other side of the line is that if it's too easy for people to obtain a right to work legally by simply staying in the UK unlawfully for a certain period of time, then more people are likely to stay unlawfully. Fewer people are going to leave when their visitor's visa expires or when they're encouraged to do so because they're overstaying. They'll think, oh, well, I just have to bide a certain amount of time and then I'll get a lawful status. So that's the thinking behind the executive's choice to have a compliant environment. Paragraph 23 gives another example of someone called Z, and in that case it's about crimes rather than complying with biodata requests. As I said, it's not necessary for either example to talk about whether they've been working illegally or whether that can be proven. It could be just someone who's, for reasons unknown, managed to fund themselves for 18 years. Now they're thinking, should I commit a crime? If 276 AD is given its proper force, they should be thinking no, because that will jeopardize my chance of getting leave in the next 2 years. But if the message of this judgment comes out and the yardstick principle sort of gains traction, then they may think, well, actually, I don't have that much to lose. I'm not jeopardizing it. I'll still have a chance to obtain leave to remain after 20 years using that yardstick. And the point really is paragraph 24, that whether you're looking at Y or Z or some modification of them, what they really are likely to draw from this case and others that follow it is not a focus on the particular details of AM's life and the fact that he was a homeless addict. It's irrelevant for them if neither of them has become a homeless addict in the 18 years they've been in the UK, and they're not likely to be. What they are interested in is this, what they would be likely to be interested in is this principle of a 20-year yardstick.
I am slightly concerned about being drawn into these things, which is how it will be perceived, because you're effectively inviting us to look at policy, because, you know, reasonable people might say, well, actually, if you really want to put off people, remove more people who you've not granted leave to remain, and or take different steps. You know, it's obviously important for the courts not to get involved in those aspects of it, or speed up the decision making and then remove them.
But it's not necessary for the court to consider or put forward sort of alternative ways of dealing with the problem of overstaying or illegal working. What is important, though, is when a court is considering the effects of their decision on the public interest in enforcing immigration control, they think about the possible effects of a sort of principle they may draw up. And those effects are wider than the facts of this case. And when the tribunal was looking at the principle of deterrence, they really pinned their consideration of deterrence to the facts of this case and the details of AM's life and his addiction and homelessness and so on. But that is not the right way of looking at it when you're thinking about the wider effects of a decision.
How does that fit in with the general balancing structure? Are you saying it's part of the public interest that the courts have to anticipate how a particular decision in a particular case might impact on how migrants here unlawfully would respond?
Yes.
I just don't. It's
well, the tribunal.
The public interest, you know, goes this way because otherwise it might lead to, even though it doesn't feature in the structure. So how on earth do we draw conclusions as to how people will respond?
Well, dealing with, firstly, with the point, why think about deterrence at all? Well, the tribunal were thinking about deterrence, and rightly so, because that was a key aspect of the public interest balance. If you focus, that's one of the key.
But you're saying deterrence is undermined if, I mean, you're essentially saying deterrence is undermined if 20 years is given undue weight.
Yes. Treated as a yardstick, yes.
That's really what it amounts to.
Yes.
And 20 years should simply have been one of the factors, not as you would describe it, a yardstick factor.
Yes. An important yardstick factor.
So is that, again, an issue of weight?
Well, as I said, it's more than an issue of weight, because it's an issue of a misdirection. Because when it's not in dispute and it's not controversial, it's sort of trite law in this context, that when a tribunal is applying the Article 8 balance, they need to think about the immigration rules and the balance struck by the executive in the immigration rules. If they've misdirected themselves as to what those immigration rules are trying to do and what the rationale of those rules are, then they will make a mistake, an error of law, not just a sort of what you might call a sort of well, it's it's a recognised error of law in this field to fail to give adequate weight to the executive's view of how the balance should be struck.
To fail to give adequate weight to the balance struck in the immigration rules.
Yes.
Which is itself derived from the executive. Otherwise, it becomes too speculative, and you then say, well, what do you think the Secretary of State thinks today? So it has to be in the immigration rules, which there are sort of ways and means of ensuring those go through Parliament.
Yes.
Yeah, no, then I accept it. I think you were just a bit too cryptic in your summary, for understandable reasons.
My apologies. So ground 3, dealing at paragraph 25 and following, it is focuses on paragraph 276 AD. And as you see from paragraph 25 of our speaking note, the speaking note takes it in a slightly different order to the skeleton argument. Because the skeleton argument begins with submissions on the near-miss principle, and properly analysed, this isn't a near-miss case at all. So that point really should be taken last. And then paragraph 26 of the speaking note, I've summarised the points in our skeleton argument about how the upper tribunal misdirected itself as the rationale of 276 ADE in two ways. The first being that they were wrong to think 20 years residence was an important yardstick for the purposes of Article 8, and as I've explained, it's not. It's deliberately more generous than Article 8 in order to provide an incentive for compliant behaviour. And then the second way they misdirected themselves is that they wrongly thought that the rationale, and this is a direct quote, the rationale of 276 ADE, in this case, reduced the public interest in refusal. In fact, it would work the other way, because 276 ADE is not an amnesty for people who've spent long enough living in the UK. It's an incentive, a reward for compliant behaviour from certain illegal entrants. And so, properly understood, that rationale should have weighed against them, not for him. It should have been strengthening the public interest on the Secretary of State's side of the balance. And this misdirection was critical for the reasons given in the end of paragraph 17. In essence, the upper tribunal should give due weight to the balance struck by the rules, and that's just the point that my Lord Justice Dingemans and I were discussing. And here the upper tribunal misunderstood the purpose and aim of the rules and put them in the wrong side of the balance, and that is not, on any view, giving due weight to the immigration rules. And it's only if I'm wrong on that that I need to rely on my first point about the near-miss principle, which is set out at paragraphs 58 to 60 of our skeleton argument. I don't need to develop orally. The reality is this wasn't a near-miss case at all. AM missed the suitability requirements by an extremely long way.
Can you just identify the passage that you say in the upper tribunal's judgment is where they say that it's a near-miss?
Yes, I think my Lord asked me about this as we were going through it. It's paragraph 143.
Right.
Where first they say, it's at page 124, that he's served half of the sentences or very close to doing so. So effectively, first of all, they've and this is the really key mistake, is they think 20 yards is an important yardstick. And then the second mistake is, having made that misdirection, they then think, well, it's more or less 20 years, which is applying a near-miss principle. In other words, a sort of principle that if you're close to meeting the rules, that's good enough.
So it's 143 and 148 again, effectively.
Yes, 143 is, yes, 143 and 148 is the near-miss.
Yeah, sorry to interrupt.
No, not at all. Then from the speaking note, you'll see that what I intended to do was just rely principally on the submissions in our skeleton argument or in relation to respondents' notice 74 to 81 and development reply only if and insofar as required. Just summarise the points. The response to respondents' notice 1 is that the respondent simply wrong as the law. The test in Kadir and MS is one of impossibility. And the response to respondent notice point 2 is that this is a challenge to a pure factual finding which gets nowhere near the necessary threshold. It's true that there was new evidence before this upper tribunal, but not before previous tribunals, in particular interview records. However, it's wholly unclear why it was wrong or irrational for the upper tribunal to maintain the earlier credibility findings in light of this new evidence. The new evidence really only just shows that AM may have repeated some aspects of his account, but so what? There are other aspects of his account that have changed over time and been found untruthful. And as I said, we'll particularize the lies and the findings on this overnight. When we've finished it, we'll send a copy to my line of friends and make sure it's available. And I thought I might, at this point, just check I've got all the questions you want our answers on. So the first question I had was a question about where the grant of permission was in the core bundle.
Yes.
That one I might be able to answer now, and just check I've understood the question right. If you go to core bundle, page 193, is this what my lady was asking about, this grant of permission here?
Was it me? Was it
No,
you
I
or
wasn't
me?
asking about
I think it was me.
Oh, sorry, it was my lord.
I think it must be, because it was the 17th of May 2011. Yes, it wasn't quite as I understood it to be described.
And this was before the change in the rules, so it was granted in the administrative court and then transferred over when it was resuscitated.
That sounds, must be right, I think.
And do we know why there was nothing happening between 2011 and 2018 on this judicial review?
I don't.
Yeah, I mean, because we know that it's then resuscitated by, it seems, correspondence.
Yes, it's quite hard to trace through the sort of the history of the litigation through court orders and the way one
would normally do.
Yes.
Right.
So that one, hopefully, I've dealt with. Now, the next question is: when did AM fail to provide data?
Yeah.
Then I have. I think am I right in thinking that you wanted me also to particularize what's the sort of basis for saying he could be removed if he provided more truthful data than he's provided to date? So I'll attempt to address that, particularize that. And then question 4 is a question of law. Can someone with an extant deportation order be granted leave to remain? My learned friend discussed this with me just during the short adjournment, and I think we're agreed that the answer is no, because of, I think, Section 5 of the Immigration Act 1971 Act. The effect of a deportation order is to cancel leave to remain, so you have to revoke the deportation order first before you can grant leave to
So
remain.
is that another criticism of the order made by this court, that they didn't quash the deportation order?
Well, if it were, it would be a
Technical one.
yeah. Because the way we've understood it anyway is that that's implicit in the order, that we'd have to do that. Then there's the question of the criminal record, which we'll attempt to agree with the other side. Then there's, are there findings in respect of the mother and brother and any attempts made to find them? Then there's a legal question about Strasbourg authorities on temporary admission in the UK terminology.
Well, I wouldn't worry answering that. I mean,
Okay.
this was really on your point in relation to positive and negative obligations, which you, I think, suggest that it's now a matter of form rather than substance.
I do, yes.
Yeah, in which case it might not get answered.
I'm grateful. And then I think those are all the questions I have. I remember there was a discussion about being given a right to work, and I wondered whether my lord...
Yes, well, I'd picked up, but it may be, one reads so much. I thought I'd found that he had been given a right to work at some stage, but I don't know whether he had.
I can hear whispering on both sides that that's right. At some point, he was, I think, given a right to work. But we can clarify that if you like. Obviously, that's not what the upper tribunal's order and declaration are about. They go much further than saying he should be given a right to work. They say he should be given a leave to remain. And
no doubt you would say that if they made an application for a specific right to work, that would then be dealt with on its merits.
Yes, I would say that. And it is possible to be given a right to work without being given leave to remain. That's uncontroversial.
So we think he was given the right to work in 2011?
For a very short period.
Thank you very much.
Mr. Dunlop, as I understand it, your submission is that the upper tribunal, or core submission, is the upper tribunal misdirected itself. So, as a result, their decision is undermined. So what do you say we should do if we agree with you that the upper tribunal misdirected itself?
If you think that the only possible outcome was one way or the other, I would submit the only possible outcome was to dismiss ground one. And then if you agree with that, then...
So it depends on that.
Yes, and if you think there are different possible outcomes, then I'm afraid, much as everyone will sigh at the thought of yet another round of AM Belarus litigation, the answer is to remit, and it can't be right for three Lord Justices to have to sort of wade through the facts and strike the balance themselves.
No, yes. Do you have any questions? No, thank you very much. Yes, Ms. Preston.
I'd like to begin, if I may, with just some overarching points, just sort of indicate my direction of travel. And then I was going to go into a bit more detail on some of the case law, insofar as that's required. And then I was going to, in the time available to me this afternoon, just turn up a bit of the evidence on what was said when, and I'll be referring to the latest disclosure by the Secretary of State because it does answer some of the questions I think that the court had about what information had been given by the respondent. The first point I'd make is, so far as I understand it, the Secretary of State does not say that RA Iraq was wrongly decided. The Secretary of State does not take issue with the way that the Court of Appeal in that case analysed the Article 8 questions that arise in what the shorthand terminology is calling a limbo case, an actual limbo case. If that's right, if RA Iraq properly applied the correct Article 8 analysis, rightly identified what the 4 questions were for any court seeking to examine whether Article 8 provided a route to some form of regularisation of status in those circumstances, then it's not clear to me, and I stand to be corrected, why this court needs to revisit the article case law itself at all.
And what is your submission about RA Iraq, that it's rightly decided?
That it's right.
Sorry to interrupt.
That was my first point. the second point, the court might want to think about that overnight, so I may put off dealing with the substance of the Article 8 cases until tomorrow. But I would say that at no point has the respondent sought to identify a Strasbourg case on all fours with the current situation and then say that the conclusion in that case compels an outcome in this. That's not how we've sought to rely on the Strasbourg cases. What we've sought to identify is that Strasbourg does not bar from its consideration and does not treat as a barrier to Article 8 considerations some of the factors on which the Secretary of State today relies. And that includes being dishonest. We say, applying the approach of the court in Hesha Valley and various other authorities, is that everything goes in the mix, and then it's for the court properly to direct itself to the principles, and then having done so, it carries out the evaluation, and unless that is flawed by perversity or other error of law, then it stands. The third point I wanted to make relates to the Secretary of State's characterisation of Rule 276 ADE of the immigration rules. In particular, on what the rationale of that rule, part of the rules is. We don't have it here, and I'll make sure I bring it with me tomorrow morning, where 276 begins. So 276 begins in the rules, and it's headed long residence. Then there's a section flowing from that heading, and then there's another heading of private life. And it's quite clear when one looks at the rules that Parliament, in approving the rules, albeit by negative resolution, has endorsed the 20-year mark as having significance. They could have said 30 years, or 10. In fact, they used to say 10. It used to be 10 years for lawful residents and 14 years for unlawful residents. That's not to say that one of the rationales of the rule might be to provide some form of incentive, but that does not detract in my submission from the point that the tribunal made, which was that the rules refer to 20 years. The fourth point I wanted to make is that we don't accept that Strasbourg distinguishes between positive and negative obligations when deciding whether to adopt the analysis of interference, that there is no such demarcation. As my Lord Justice Moylan pointed out, what the court was doing in jeunesse was to identify that in that case, the court wasn't concerned with an expulsion. It wasn't suggested that it would be any less of an interference if the consequences of the decision would be that the applicant in that case wouldn't be able to continue family life with her husband and children. The fifth point I wanted to make was about context, and I did try and flag this up by trespassing on Mr. Dunlop's submissions earlier today, and it's this point. This is not a case in which the consequence of the upper tribunal's order is that this individual cannot be removed. The order does not touch on removability. It doesn't touch on the circumstances in which private life rights prevent a person from being removed. It's not that order of case. The only thing it does is say to the Secretary of State, unless or until you are in fact able to remove this person, the point has come where you have to regularise their status for all these reasons. And I'll come back to those. Why is that important? Well, for two reasons. One, the primary legislation to which the Secretary of State refers, the Section 117 sections, I don't go so far as to say they weren't relevant, but I do say that they're fulfilling a different function, and a court considering those sections is fulfilling a different function and addressing a different mischief to the court in this case. Those sections are designed to direct a court to the matters which it must have in its mind before it makes a ruling, the consequence of which is that a person may not be deported.
Is that true of both A, B, C, etc.? Because B, I think, is in terms of any exercise of immigration powers, which granting
Yes.
leave to remain would be. So it directly applies, doesn't it?
Yes. Let me just turn up the section if I may. Yes, public interest consideration is applicable in all cases, but it's right. It's right, it seems to me, that all those considerations come into sharp focus when the question is, can a person be deported or not? So, for instance, we see that 117b6 refers to people who are not liable to deportation, but to removal. We would say that the mischief being addressed by Parliament in these sections is where courts, and I think this was an expression used by Mr. Dunlop, adopt too generous an approach to the question of whether a person should be protected from deportation or removal or not by virtue of their private life rights. Now, as I say, I do not go so far as to say that Mr. Justice Lane and the upper tribunal didn't have to have regard to those sections. They did, and I don't argue with that, but that's the context in which those sections were applied. I'll give an example of a similar sort of context, and that is one where leave is granted not with a view to progressing through the 4 times 30 months tranches of leave leading to residence, but on a temporary basis outside the rules. An example would be where there are ongoing family proceedings which touch on family and private life matters which may have bearing on a deportation appeal, and the Secretary of State grants a short period of leave to cover the period of those family proceedings so that those can be concluded, and then the court looking at the deportation question can have the answer given by the family court in those cases. So that's a situation outside the rules, as this is. This always was a situation outside the rules in which Article 8 comes into play in its own right. And that is another situation where a pragmatic solution has been reached to cover the situation of a person facing deportation, but there are reasons why leave has to be granted in the meantime. The Court of Appeal authority for that is a case called MS Ivory Coast. I can bring it tomorrow if required. So, although it's right, and I agree with Mr. Dunlop when he says that when looking at an Article 8 case outside the rules, the court must nevertheless have a look at the sections and the rules to see what Parliament says about where the line should be drawn in those circumstances. In an outside the rules case which isn't itself concerned with removal or deportation, in which the tribunal is not being asked to rule on that issue, the way that the tribunal applies those sections and those provisions has to be viewed in that context. Another example of controlled periods of leave being granted outside the rules is restricted leave. So that's a situation where the Secretary of State accepts that removal would breach, say, Article 3, but there are very serious reasons, such as very serious criminality or terrorism-related matters, national security matters, which mean that the Secretary of State doesn't want to lose sight of the possibility in the future that that person might be removable. And in those circumstances, the court has upheld the Secretary of State's policy saying, well, you can keep somebody on a limited period of leave and turn it around every 6 months or every 12 months, depending on keeping sight of the question of removability and keeping sight of the question of the impact on the individual, but it's a lawful policy. So that's another example of a situation outside the rules where the Secretary of State has developed a means of accommodating that situation without engaging or without triggering the pathway to settlement.
And is that with full right to obtain work benefits, etc.?
Normally, yes.
And are there any authorities dealing with that situation?
MS and MBT in the Court of Appeal, lead judgment by Vice President Underhill. I was in that with Stephanie Harrison. We both lost. She did better than I did. So there are a range of circumstances in which the courts recognise, and the Secretary of State, with enough encouragement, recognises that a pragmatic solution outside the rules has to be reached where the Secretary of State doesn't concede, and the court hasn't found necessarily, that the person is entitled to some form of leave under the rules, but nevertheless, they're going to be here, and they're going to be here for the foreseeable future. So then what I was intending to do now, if I may, is to go to RA Iraq and just take the court through, because we haven't really looked at it in a great deal of detail. And we find it in the authorities bundle 18.
It is extensively summarised or quoted in the Upper Tribunal's decision.
It is. It's worthwhile, though, in my submission, just having a look at a couple of matters, including what the court was being asked to think about in that case, and also the detail with which the court went through the available authorities. So, at paragraph 26, you can see ground 1 is summarised at the bottom of the page, 499.
Sorry, can you give it to me again? Which
It's
paragraph?
paragraph 26 at the
Thank
bottom
you.
of page
Yes.
499. And the court's review of the domestic authorities begins at 501. So we can see there at the bottom of the page, paragraph 34, the court deals with Kadir. And then my learned friend Mr. Dunlop has gone through that case. I don't intend to take the court through it again. It's just that we can see that the court had firmly in its mind the approach taken by the House of Lords in that case. And I again concede or accept that the same reasoning applies mutatis mutandis to Schedule 10 immigration bail. And then we can see the next case is an application for permission in the case I was in, which arose shortly after the judgment in Mendizabal became available. And the court takes account of what the Court of Appeal considered arguable in that case. That case was conceded after the issue of permission. Sorry, by the Secretary of State, not by me. And so that was a case, an early case in which the concept of immigration limbo was articulated.
So you say that, contrary to Mr. Dunlop's bright line, there is no authority in which this has been done before, and the whole world will collapse if it happens. Rahman was such a case.
Yes.
And do we know, I mean, apart from obviously your recollection,
Yes.
whether there's an order showing that...
I can endeavour to get hold of that for
that'd be
tomorrow.
very helpful, thank you.
I'm not sure whether it's said in terms and upon the Secretary of State undertaking to grant some form of leave. I'll have to check with the solicitor in that case exactly what happened.
But that's always important, because sometimes it's very, all the cases can sometimes run together, and it's just better to have chapter and verse.
Understood.
Okay.
And then the case of AR, and this was a question relating to detention or temporary admission, and that case turned on the Section 67 question at the bottom of the page, whether there were practical difficulties impeding or delaying the making of arrangements for removal. Does the court need me to turn up Section 67? It's right at the front. Thank you. And in that case, the court paid particular regard or recorded what Lord Justice Torson had said in the context of the Article 8 rights. Took that into account. And then there was the judgment of Lord Justice Beatson and Stanley Burnton in Abdullah, once again dealing with the question of the relationship between Article 8 and the limbo, circumstances of ongoing limbo. And in that case, the period was very short. It was 21 months. We see that halfway down paragraph 41. And then, in light of that particularly short period of time, we see Stanley Burnton's conclusions in respect of that period of time and the relationship with Article 8. But then we see Lord Justice Beatson adding 2 observations on the Kadir case. And then at paragraph 28, halfway down that top paragraph, once again, that court plainly saw the period of time of limbo as being very significant indeed. Then the 5th case that the court looked at was the case of Hamze. And that's where one finds the observations of Mrs. Justice similar. We've already referred to those today. And then, in particular, we notice the observations of Lord Justice Underhill at paragraph 47, relating to the permission hearing.
Albeit in the context of never rather than just remote.
Well, yes. Yes, that's right, and that reflects the sort of impossibility threshold imposed by Kadir. But I don't understand Mr. Dunlop to have demurred from the analysis. In fact, he's expressly accepted that the lesser threshold identified in RA.
Well, on the basis, as I understood it, and I hope this is a fair summary, that if it's impossible, then you've got a common law remedy,
yes.
And therefore Article 8 must be biting at something lower,
Yes.
albeit he says very, very rarely, if at all.
I understand, and that's fair. Yeah. I don't demur from that analysis. I think this is precisely the rarely, hardly ever type case that the upper tribunal had identified. And one hopes it would be hardly ever. And then there was nothing in specifically that I wanted to take the court to. The court can read through for itself, paragraph 49. The next case is BM Iran. Before leaving Hamza, I would just say that it's certainly no part of my submissions that the Secretary of State is required to have a policy in respect of granting leave in these sorts of circumstances, or that by not having a policy the Secretary of State is acting unlawfully. In my submission, what the upper tribunal has identified is a very precise and unusual constellation of circumstances which it has concluded just tip this individual over the threshold for Article 8. Tip the balance. So BM Iran, this was again a period of 5 months. See that from paragraph 51. And we can see Lord Justice Richards rejecting the limbo argument. We can see that he wasn't impressed with the way that private life argument had been put. He's described it as an unduly ambitious attempt to establish a positive obligation under Article 8 to promote the opponent's private life. But he concludes there might come a time when a continuing state of limbo would give rise to issues under Article 8, but that is a matter for the future. Again, identifying that time was a significant aspect. Abdullah, there's a short reference to that case here, concerning a grant of TA, so it's the Kadir point, a grant of temporary admission instead of a form of leave when it was recognised that an individual was not removable. And paragraph 54, the UT rejected the claim based on limbo grounds and emphasised that the approach outlined by Lady Hill was focused on the future prospect of removal, not on the historical inability to remove the claimant to Iraq. So that seems to distinguish the approach taken in that case. It's not clear from the extract there, forgive me, whether there was any evidence at all about future removability. And then the 8th case is AB Sierra Leone. And in that case, Lord Justice Haddon Cave notes halfway down the paragraph under 55. The question before the Court of Appeal was whether on that date the first-tier tribunal had materially erred by concluding there was a realistic prospect of ABs being removed to Sierra Leone or leaving voluntarily. The Court of Appeal considered that limbo had not yet become a live issue. AB had been non-cooperative, disruptive and inconsistent, albeit probably on account of his poor mental health. And then we see the digested conclusion of Lord Justice Beatson at the bottom of the page.
So, on that review of the domestic authorities, is this right? The case of Rahman and one of the cases in MS, after it went back and we were told the appeal was allowed and leave granted, are examples where limbo Article 8 leave has been granted?
Yes. I don't understand there to have been an exhaustive trawl by the Secretary of State, because of course the Secretary of State's in a much better position than we are to know the circumstances in which, but of course policies change, and it may be, and emphasis changes and the law changes, and it may not be that much can be read into previous grants of what I might in shorthand term as limbo leave. I certainly accept and would accept if it was put to me that the Secretary of State has the right to have different rules and policies, change the rules, put them before Parliament. I can't say that the circumstances as regards the Secretary of State's approach to those questions is the same as it is now.
So when you told us you were going to tell us when paragraph 276 ADE, on which Mr. Dunlop has placed a lot of reliance for rationale and policy.
Yes.
When was that introduced?
I think the latest version was in, well, the bit that incorporated private life was introduced in 2012.
And that included the 20 years, was it? Or when did it go up to 20 years?
I think that's when it went up to 20 years.
Thank you.
I can check that, but I understand that it was part of the raft of changes sought to introduce into the rules, into the immigration rules, Article 8 exercises which previously had been outside the rules. So it was that was, I think, in force 9th of July 2012.
Thank you.
But I will check that overnight to make sure the court has it tomorrow. So that in my respectful submission is a comprehensive trawl through the cases brought to the court's attention in which the domestic courts have been looking at what happens to individuals and where they seek to argue that Article 8 means their status must be regularised. And once again, when I say regularised, I am not talking necessarily about, for instance, being put on the road to settlement under the rules. I'm talking about leave outside the rules, which is a temporary means of regularising their situation, rendering them lawfully present rather than unlawfully present, with the raft of consequences that flow for them, but without necessarily putting them on a path to settlement or any long-term entitlement to residence. The only difference it might make is if, let us speculate that an individual was granted this sort of a form of short-term leave outside the rules, they would then be in a better position than somebody who was seeking to accumulate private life rights when unlawfully present, but they would then be caught by 117C6, I think, which makes the reference to precarious forms of leave. So if they weren't on a form of leave which is leading to settlement, then little weight would be given to their private life in any event, because it was built up at a point at which they had leave with no expectation of residence permanently. Does that make sense? So what I'm saying is they might be in a moderately better position than somebody who was unlawfully here, but not much. And that might be one advantage.
Is that what's meant by 117B5, precarious immigration status?
That's what I meant.
Yeah.
That's what I should have referred to.
No, don't worry. It was a bit cryptic, but I think I got there.
So might I turn back then to Lord Justice Haddon Cave and his review of two of the Strasbourg law? There were only two cases that he was referred to, and we can see them at 507. One was HLR in France. And then the other one is Mendizabal, with which the court's familiar. Then the discussion on the authorities. And I don't understand anyone to be disagreeing with the approach taken at paragraphs 59 and 60. In particular, while the authorities acknowledge the theoretical possibility of a state of limbo, giving rise to a breach of Article 8 rights, it's striking there is no domestic case in which such a limbo argument has succeeded, and that's right insofar as the decided case law that he reviewed.
But they had succeeded later by subsequent grant.
Yes.
Yeah. And I think Mr. Dunlop criticised the summary in relation to Mendizabal in paragraph 60 by saying yes, but it missed out important bits.
Yes, I don't suppose that was a comprehensive analysis of all the factors in the case. The facts of the case are rehearsed at paragraph 58. So then the four-stage test is set out on the following pages. As I don't understand any dispute to be taken about the correctness of that analysis. My understanding with Mr. Dunlop's submissions is that he takes issue with the way that the upper tribunal addressed those matters. But it does, in my respectful submission, identify a principled basis on which the court can apply the well-known approaches from the case law, from the Strasbourg case law, and consistently with the approach taken by the domestic courts in the case law that was reviewed. My overarching submission, without reading out all the four stages with which the court's familiar, is that there is nothing in the Strasbourg case law to which Mr. Dunlop directed the court which undermines the correctness of that approach. bearing in mind that the principle of the margin of appreciation is to ensure that courts applying the broader principles from Strasbourg do so in the context of their own domestic legal arrangements.
If it's common ground that this is the test set out and there's a balancing test, in extradition cases, very frequently, there were complaints that the district judge ordering extradition or ordering discharge had come to the wrong sort of conclusion. And after a lot of toing and froing, the divisional court said, the former Lord Chief Justice said, that the court should interfere only if the balance was wrong. Would you accept that as an appropriate similar test to apply, or would you argue for something different?
In the context of this form of fact-sensitive evaluation by the specialist tribunal, I would say that the Secretary of State would have to identify a conclusion that the upper tribunal weren't entitled reasonably to reach. Either because it was for all the standard public law grounds, either it failed to take into account the material matter, reached a conclusion which wasn't sustained by the material, failed to took into account irrelevant matters. Those sorts of errors of law would have to be identified.
But there is a right of appeal on the basis of an error of law from the upper tribunal, similarly to the extradition. And when you are balancing things, then, I mean, if one looks at Zielinski, they just said, it's much easier to say, has the judge gone wrong?
Yes, it may just be dancing on the head of appeal.
Yeah.
And that's the way that the ground is put in the CPRs, in 52C, I think it says. The court below was wrong to reach the conclusion. But anything remotely like a disagreement wouldn't be anywhere near sufficient.
Well, a disagreement about what weight to give to which factor.
How much weight to give isn't the question. It would be whether the tribunal gave weight which it reasonably was entitled to give. So, just going back to RA Iraq, if I may, that was an unsuccessful case, but it's can be quite helpful to look at the factors that resulted in that appeal being dismissed. First of all, of course, this was an appeal from the upper tribunal itself, not the tribunal applying for itself the principles. So the way that the Court of Appeal reviewed the approach taken by Judge Allen in that case is simply to review that the way that the court, that the upper tribunal in that case approached the evidence, and it's, I have to say, actually, having re-examined it now, there's nothing hugely of assistance, because the court was dealing with specific grounds of appeal in respect of the upper tribunal's approach, and it might actually only be helpful to look at that if one had the upper tribunal judgment, which we don't. But
well, you have it summarised at paragraph 73.
Yes. 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 On the facts, at the bottom of paragraph 74, the appellant has been able to continue his private and family life in the UK, work and provide financial and emotional support for his children. Actually very different. And then at paragraph 94, 511, Judge Allen was right to dismiss the claim. This was not a case in which it could be said that the prospects of the appellant's removal to Iraq could be said to be so remote that it would breach his Article 8 rights or be irrational to deny him continued status here. So, again, different findings on the facts to the ones that made by the upper tribunal in this case, with a similar approach.
Although Mr. Dunlop does stress in this case the fact that it's all AM's decision not to allow himself to be removed on the findings which bind us.
Yes.
And what do you say about that?
Well, I was going to take the upper tribunal's judgment and just pick out the bits that I said. In essence, we would say that the upper tribunal made findings and took them all into account. It can't be said that the upper tribunal didn't properly direct itself to the worst aspects of this case. It did so. Notwithstanding that, it concluded, I'll come back to it, it concluded that the balance tipped just in the appellant's favour. And again, the consequence of that would not be that he would be on the road to settlement. The consequence of that judgment would be that the Secretary of State would have free rein to decide what kind of leave to grant him in order to render his status lawful as opposed to unlawful, regularised as opposed to irregular. At this point, I wanted, if I may, to turn up the evidence which I say may assist the court in referring to what was said when and by whom and who. The most helpful evidence that I've found, and I have to apologise because I'm coming to this case very fresh and Mr. Carnick behind me may want to correct me if I make a wrong submission. The most helpful material is in the supplementary bundle. It forms part of the most recent set of disclosure, which I understand. May I turn my back for a moment? Not all come at once, but it was disclosed from 2019 onwards. The document that I was suggesting that the court may find of assistance is at page 124. Begins at 124. Sorry, supplementary bundle. That should be a document which appears to be headed by a fax.
Yes.
Indication at the top, yes. So I understand that document to be a review conducted by an officer of the Secretary of State's. We see initial CW at the end, page 130. It's a helpful document, I suggest, because it seems to me to be an even-handed sort of a document. And sets out the purpose of the review and what Mr. M says about the about his circumstances, and then sets out some historical context at the bottom of the page. And some reference to rules in play at the top of 125. Again, this is an indication of rules. When the Secretary of State receives an application, they go through a process of looking what rules it fits under and then looking outside the rules. And then makes reference to criminal convictions. I don't know if the court just wants to read through 125. It gives a history of the interviews.
What are we taking from this?
So, what this document does, in my submission, is provide a helpful and rather detailed resume of all their contacts with this individual when he's been asked to give information about his identity.
Okay.
And it is a Secretary of State's document, so I'm not seeking to persuade the court that a document that I have prepared or that those sitting behind me have prepared is one to which the court should have regard. My submission is that this is a helpful document, and it's one which the Secretary of State had prepared. And in particular, it's helpful if one turns over the page. We can see that there is an indication there of all the information that's been given on the various occasions on which it's been given. So although it doesn't have dates, and that would have been helpful, we can see 10 versions of the name. They're all relatively consistent, but we can see that there appears to have been an inconsistent patronymic given at ID 5 and ID 6. If we look down the page, we can see that consistently the same date of birth and place of birth has been given. And the Secretary of State notes at the top of page 127 that that's been consistent. Date and place of birth and address. And then we see information given about school. And then we see information about Book Factory, which is his place of employment, and he had earlier produced a work card or work identity card, and that is found at 140. So this is a place where he says he worked at 1997 before he left. And you see mother's details. Suggests over the page that he's not been consistent. If we look at the first name is consistent, the last name is consistent, and then there's, in some places there's a reference to a patronymic, and in other cases there's not. So, as I say, this is all information which was relatively recently disclosed, certainly before any of the first-tier tribunals' decisions. In addition, the disclosure includes interview records. I think the court's made reference to them. and also information about checks which were carried out. So, for instance, my understanding is that the work card at page 140 has been rejected as a form of as a genuine document because checks were made by the British Embassy in Minsk in 2003. Actually, we see it's in 2001. Page 161. You can see in relation to the factory document, you can see there following inquiries made 161. The document which was given to you by above is a forgery because A, such company does not exist in Belarus. That's book factory 2. I called the factory with a similar name and they confirmed that nobody with the name M had ever worked for them. They do not have any identification cards. And I called them Ministry of Health. They confirmed that the company does not exist. And they do not deal with any industries at all. So that sort of gives an indication. Obviously, my understanding is, and those sitting behind me will correct me if I'm wrong, that because these documents were quite recently, relatively recently, in the scheme of things, disclosed, then it wasn't possible to seek to chase up or to further investigate what had happened with that and why. Particularly, for instance, it might have been possible to ask for expert evidence in respect of that. One doesn't know. I don't want to speculate. But anyway, so the court has here what is in my submission, helpful summary of all the information given to the Secretary of State.
There's, at the bottom of 129, it says that he's agreed to take part in further action to establish his nationality.
Yes,
this is 25th of January 2019.
Yes.
And we know that at page 135, on the third box up from the bottom, there was a telephone interview between him and the Belarusian officials. What's not clear is the result of that telephone interview.
My understanding is that the Belarusian officials rejected him.
I'm sure that's right, otherwise we wouldn't be here.
Yes.
but I couldn't find out exactly where it said that.
I'll just turn my back if I may. Yes, in the CSI notes that have been disclosed to us, we don't have any additional information about what had happened. But there are some anomalies which are odd. For instance, the reviewer, CW, of the information given by Mr. M, from February 2003, it's recorded at page 125. Yes. It's at 125. I'll take the court to it. Yeah, 115. Sorry. Yes. Just what I said was that there was nothing other than the GCID record note. But just if I may, at 125, we can see this slightly odd record under the line in February 2003. Following the interview with the Belarus consular official, there was a difference between Mr. M's and the consular official's recollection, with the consular official stating that Mr. M had categorically denied being a Belarus citizen and suggested that Russians pose as Belarusians and that he was buying time by giving false details. And then at the bottom it said the consular official referred to 2 broken front teeth, whereas Mr. M did not have 2 broken front teeth. I don't know if there's anything in addition to that. There might be. But that's what the exchange is recorded by the Secretary of State. So it raises a concern about who the it raises a concern about why Mr. M would have categorically denied being a Belarus citizen if he was a Russian posing as a Belarusian. But it gives rise to anxieties about whether there has been 100% bona fides on part of the Belarus authorities, and indeed so much was noted by the upper tribunal on the back of Mr. Chenstoner's report, which the court also has.
On page 130, the last entry, and the entry before, there are 2 different spellings of Mr. M. Are they meant to refer to the same person?
Maybe. May I just turn my back? I have to say, we don't know what that refers to.
Yeah, it may just be a typo.
Yes.
But it's a slightly odd one to me.
Yes, and the court may already be familiar with the phenomenon that individuals, it's suggested, don't give consistent account when the spelling is changed. Sometimes if you transliterate things from Cyrillic into English, I don't know what the outcome is. But anyway, if I had this case now, you know, there'd be things I'd be doing, but I'm not in that position.
No, we are on appeal.
No. But there are anxieties, and those anxieties, I say, go to the upper tribunal's correct conclusion that removal is sufficiently remote in this case. Because there are complex matters at work. In addition to the legal facts relating to the extent to which Mr. M has been honest about his identity.
But just on a fairly narrow factual basis, it would appear that as of the 2nd of August 2019, that was the last occasion upon which there was contact with the authorities in Belarus in respect of this applicant. Is that correct?
That's not for me to answer, my lady.
No,
as far as I know,
clarification from Mr.
Yes.
Dunlop, but insofar as we have documents before the court, that's what it appears to be.
yes. May I turn my back for a
Yes, of
moment?
course.
I recollect that in various places in the evidence, the respondent has suggested that the Secretary of State's forgotten him. I don't know where that times in with the timing of things, but certainly that's something that's been a bit of a theme with this individual during the period of the 20-odd years. So, with the sort of half an hour left to me this afternoon, I was wondering if, unless the court's sitting to 4:30, I don't know what the position is.
Well, provided if you want to go on to, how much longer have you got?
Well, I was going to take the, if the court accepts my submission about RA Iraq and where Mr. Dunlop's position on that case takes us on Article 8, then I don't need to go trawling through the
Yes.
Article 8 case law, and that can cut down some time. I was hoping to get through my positive submissions in respect to the upper tribunal's that's to say, upholding the reasoning of the upper tribunal.
Should we go on till about 4:15?
Yes. Well, what I was going to suggest is if I can get through quite in a fair crack what I say about the upper tribunal's judgment, bearing in mind the court's already been through it once, then if and to the extent that I want to continue to press the matters raised in the respondent's notice, I'd rather think about that overnight and let the court know in the morning if that's acceptable to the court.
Thank you.
The reason I make that comment is because obviously make that suggestion about the respondent's notice is because the skeleton in this case was drafted before the Court of Appeal gave judgment in Katie, and I wanted to think very carefully about what Lord Justice Singh says about the threshold of remoteness in the context of the common law argument, which is the first point raised in the respondent's notice. If that's fair. I regret not being in a position to have a definitive position on that, but certainly I've been assisted also by Mr. Dunlop's submissions. So then if I might turn up the other tribunals. Forgive me, I'm working from several bundles to try and make sure that I'm using the right pagination. So the first point I wanted to come back on in respect of the court, of the tribunal's analysis, is the point that Mr. Dunlop makes about how the tribunal addressed the issue of the so-called 20-year yardstick. Now, sometimes when we are going into the granular application of a qualitative right, we can lose sight, I'm sure this court never would, but just for my own purpose, we can lose sight of the sort of overarching principles. So we recall that articulate, and indeed the convention, is a living instrument. It's designed to be sufficiently flexible to secure effective, not theoretical, remedies and vindications in respect of the myriad of circumstances which are visited upon an individual. And so it's hardly to be expected that there will be a case on all fours that we can point to. If the approach taken by the court is one which is consistent with the general principles afforded and the sometimes nuanced approach that an upper tribunal evaluating a complex situation has to adopt, then the absence of any specific circumstance having arisen in that way before isn't a bar to the conclusions reached by that upper tribunal. The second overarching point arises often in the context of upper tribunals' judgments, or indeed first-year tribunals' judgments, and indeed it's something which is quite often said to me, and that is that we must remember to read the judgment as a whole and not just take out bits of it and criticise them. Nor should we advance on the court a counsel of perfection in respect of the phraseology adopted. And I've already provided to the court a copy of AH Sudan, in which Lady Hale makes the observation about the importance of recognising the specialist expertise of the upper tribunal. Of course, here we're dealing with the President, the Constitution chaired by the President. And indeed, UTJ Remington, also very experienced. So, against that background, I would say the following in respect of Mr. Dunlop's criticisms. First, in respect of the observation at paragraph 125, that the appellant is to be treated as a vulnerable witness. On the evidence provided to the tribunal, I shan't take the court to it, there's no criticism of it, a lot of it is already before the court. The tribunal is simply acknowledging that this is a person in respect of whom there would have to be an inquiry as to whether any special arrangements should be made for him to give an account of himself. That's what being treated as a vulnerable witness means. That was wholly relevant and open to the tribunal to take into account. Just forgive me, I've picked up the wrong highlighted version of the tribunal's judgment where I had identified to myself exactly which bits of the... forgive me. Yes, sorry, I missed out. If I could go back, if I may, to the beginning of the consideration of the four stage inquiries. Paragraph 120, page 119. Mr. Dunlop criticised the reference there to the 14 years. In my respectful submission, that's simply an observation. As part, it goes into the mix. It's not treated as a conclusive matter. And it's certainly a material consideration that the court should have taken into account.
Sorry, which paragraph was that?
Paragraph 120.
Yeah.
When there's a reference to the 14 years in Mendizabal. It's clear when one reads the rest of the reasoning that the court hasn't decided that that's determinative of the issue of whether Article 8 requires some form of regularised leave in this case. The court finds, the tribunal finds at 123 that there is minimal private life through friendships. So they've obviously taken into account the minimal level of the private life rights in play or developed. I've already dealt with the 125 criticism. Court undertakes a summary of the medical evidence before it, which it was all proper to take into account, and notes at 129 that it's unlikely that if he were given leave to remain, he would become a model member of society. That was open to the tribunal and indication of a balanced review of the material before it. Coming on then to the court's treatment of the tribunal's treatment of the issue of the public interest, if we turn to 134, and this is the approach taken by the, in my respectful submission, that possibly didn't wasn't lingered over by the Secretary of State in submissions, at the bottom of paragraph 134, dealing with the public interest. In the present case, the residual public interest resulting from the applicant's problematic actions and his criminal offending has to be seen in the overall context of the highly unusual circumstances of this case. In my respectful submission, it was plainly open to the tribunal, with its vast experience, to find the circumstances to be highly unusual. On the question of deterrence, the tribunal, we say, asked itself the right question. Bottom of paragraph 135. Parliament has decreed that working and relying on benefits should be withheld from those who are in the United Kingdom illegally, in part as a disincentive to coming or remaining here illegally. The stark question in the present case is whether that principle of deterrence is likely to be damaged by the grant of leave to this applicant. So it's plain that the court wasn't just thinking of what the man in the street might think, but also migrants who might be affected by the outcome. Following its reasoning, we say, in paragraph 136, it was reasonably entitled to come to the conclusion that a grant of leave to the applicant at this point is unlikely to encourage others to follow his example. That was a conclusion that they were entitled to come to on the material before them. We also recall again that the form of relief that they are providing is not one which leads to settlement. It's a temporary recognition of a state of affairs. And indeed, the upper tribunal was correctly silent on what form of leave that might take, which is wholly up to the Secretary of State. On the question of the yardstick at paragraph 142, I've made my submissions on what the intention of the rule is, and tomorrow I'll bring with me a complete copy of that section so that the court can see how the headings are broken down in the rules. Not only is the reference to 20 years as being significant open to the tribunal, it also reflects the previous domestic jurisprudence that I took the court through, summarised in the RA case.
And what about Mr. Dunlop's point, which is that by saying it's an important yardstick and just looking at the period of time, but failing to give requirement or any acknowledgement of the provisions disqualifying this particular applicant, the tribunal has misdirected itself?
This is an outside the rules case and always was. There is no suggestion here that this is an application within the rules, or the court is being asked to allow the case under the rules. What the tribunal is noting there is that in the rules identify 20 years as a significant period. Of course he doesn't satisfy the rest of the requirements. That's why he can't make an application under the rules. This is only a form of ensuring that the approach taken by the court to the particular articulate issues arising here, because of course 276 ADE itself is a path towards settlement. I think a successful application under 276 ADE gets you 30 months with the expectation of being eligible for ILR within a 5 or 10 year period, depending on the extent to which you satisfy the rules.
The other point Mr. Dunlop made in relation to this was that he said, well, they've also not picked up the rationale of 276 ADE, which is to encourage good behaviour.
That must be right, and certainly would be highly relevant in the context of an application under the rules. For the reasons I explained when I opened, I think it was my point 2 or 3, about what the aim of the rules is, what the rationale of the rule is. The rationale of the rule can encompass a number of aspects. We certainly don't deny that one of the aims of the rules is to encourage a certain form of behaviour. But it's important to recognise that there are going to be cases, and this is one, where none of that behaviour has been complied with, and that's why the application has to be outside the rules rather than within them. All the tribunal is doing there is noting that some significance is attached to the 20-year period by Parliament in the context of that part of the rules. That is to say, it's an indication, and an important indication, that there is a degree of acceptance that after 20 years, a certain amount of private life interest will have been set up, will have been established. How far that takes you is a different question. Again, it would be right to say that in all the domestic cases that I took the court to, the elapse of time was significant, and we simply say that the court is noting that the 20-year period has been identified as a significant period in the rules. It's unfortunate that that sentence is unfinished. I know that my learned friend did speculate about how he would finish that sentence. I don't think I would have finished it in the same way. I would say that it's an important yardstick in determining whether the right to respect for a person's private life is engaged. Certainly there's no indication in that paragraph, reading it as a whole, that the upper tribunal has treated that yardstick in any way as determinative. It hasn't. Except that if it had done so, it would have made an error. It's right to say we submit that the paragraph 147, contrary to the earlier submissions of Mr. Dunlop, that the tribunal did have regard to section 117B of the 2002 Act. And again, I don't think I could add to the court's observations previously about the way that the tribunal has expressed themselves there. I simply say that the court's plainly mindful of the precarious state of the individual. I mean, that's why they made the decision they made, because he was, partly because of the impact on him of that protracted period in those circumstances, in those conditions. And then on the question of paragraph 149, in my respectful submission, that is a very well-informed paragraph. That is a paragraph written by a tribunal succinctly recognising that this case falls outside the run of cases that come before it, is genuinely exceptional in the true sense of the word, against the background of having seen very many cases indeed, and being painfully aware of where Parliament has drawn the line in respect of deportation, removals and the public interest. In essence, we submit that none of the criticisms of the Secretary of State identify an error of law or a misdirection sufficient to undermine the conclusions in respect of ground 1. That's to say, the respondent's ground 1 in the judicial review. I had prepared to make some submissions on the general approach to Article 8 and the sort of flexible approach. They're identified in the skeleton argument already, and they are so they're highlighted there. But they're probably going to be authorities with which the court's familiar, like Hesham Ali. I don't know whether it's just worthwhile turning up a couple of paragraphs.
Yes.
So Hesham Ali is at tab 8, page 241. Also, I had prepared to make some submissions on the issue of positive and negative obligations in this context being a distinction without a difference, but I understand that Mr. Dunlop for the Secretary of State has already effectively so indicated, so I shan't take the court to them unless the court wants me to. So this was a deportation case, and it was a case in which the court was being asked to reach a view of whether the effective codification in the rules of the approach to be taken in Article 8 cases, in deportation cases in which Article 8 was a factor, was effectively tying the hands of the court. Whether the court, what was the approach, the proper approach that the court should take, including where the circumstances that the court wished to take into account weren't included in the rules and necessitated a tour outside the rules. The particular part of Hesham Ali that I wanted to take the court to was the reference to the consistent thread running through the cases, the Strasbourg cases on Article 8. It begins at paragraph 115. And it's subheaded the message provided by the Strasbourg cases. And it's talking about the proper scope of an Article 8 inquiry. In particular, Lord Kerr says at 115, he refers to the need to review and assess a number of specifically identified factors in order to conduct a proper Article 8 inquiry. Another theme is that this examination must be open-textured, so that sufficient emphasis is given to each of the factors as they arise in particular cases. Of their nature, factors or criteria such as these cannot be given a preordained weight. Any attempt to do that would run counter to the essential purpose of the exercise. This can be readily exemplified. A significant prison sentence may be offset by the strength of family ties. And then it notes that expulsion might be justified where the offending is relatively minor. So what Lord Kerr is saying there, and I don't understand it to run contrary to the judgment given by Lord Reid, is that, and paragraph 120 spells it out, the European court cases do not permit a national policy which limits or dictates the weight to be given to the abusive factors in the Article 8 balancing exercise. Now, as I say, this was not the lead judgment. What Lord Kerr Lord Kerr describes it as important differences of emphasis at the open of his judgment. But I don't understand that description of the Strasbourg case law to be incorrect or to be disputed. What my submission would be that it's clear that what the Secretary of State is seeking to do is to close down the scope of the upper tribunals, in this case's discretion to ensure that Article 8 is sufficiently flexible to encompass the rare, the extreme, the unusual, the exceptional. And my submission would be that there is no challenge to the facts set out by the upper tribunal, by the Secretary of State, and therefore we would submit that nuanced evaluation was properly for the tribunal, that it would be wrong in principle, and Strasbourg does not, bar consideration of any of the factors relied on by the upper tribunal. And that the upper tribunal retains a significant degree of discretion as to those matters which it considers particularly significant. And so long as, looking at the judgment in the round, it does so reasonably, there's nothing in my submission that the Secretary of State can point to say that that conclusion is unsustainable in law. May I just turn my back for a moment?
Yes, you said that you might have referred to some authorities on the positive-negative distinction between being a distinction without a difference.
Yes.
Do you just have a list of those with the paragraphs that you were going to refer us to? So don't take us to them.
Yes.
But do you have the... are they in your written submissions?
I think that what I had done in preparation was simply to highlight them. I can provide it in the morning if that's helpful. I can provide a written list, or I can take the court just through the references now.
Would you just want to do the references now? Have you got them there?
Yes. So in Agyarko at 41, page 312 of the bundle.
Says Agyarko, paragraph 41.
Yes.
Yes.
I think that Osman is already cited in the skeleton argument.
Is it paragraph 65?
Of the skeleton?
Yeah. It may not be. It's simply recited at that paragraph.
Osman 53.
Yes, 53 sounds familiar.
Yes.
Yep.
As I'm essentially agreeing on this, I can contribute one myself.
Do.
Hesham Ali,
Yes.
paragraph 32.
Thank you.
Sorry, which was the paragraph in Osman? 50, was it?
53.
53.
Thank you.
Also, there's a typo in the skeleton that I wanted to correct for the court. That reliance is placed in the skeleton on pinnock.
Yes.
In paragraph 65, there's a reference there to. At paragraph 65, it says, secondly, the Secretary of State has not in any event shown the approach of the UT was contrary to a clear and consistent line. That should actually say clear and constant line. And we find that in paragraph 48 of Pinnock, which is in the supplementary bundle at tab 2, I think, by memory. Yes, tab 2 in the supplementary bundle of authorities. Yeah, as I say, it's clear and constant, not clear and consistent. Is the direct quote from the case.
Right. Okay, that's probably. If you want to add any, you can do that.
Yes, in Nunes and Norway, at paragraph 69 also, and we find that
27.
yeah, sorry.
Don't worry. I just asked you to give us what you're doing, which is the paragraph number.
Yeah, so Nunes is tab 27, and the relevant paragraph is
69.
yes.
Yes.
That was the last.
Right. Thank you.
There are more references in the skeleton if we take a look from paragraph 66 onwards. I think I've covered most of them. I think there's a reference here to Keeler.
Yes.
And that's paragraph 69 and 70. I think one of the reiterations in Keeler was the point that I made earlier, which is that court in Jeunesse was drawing a distinction between an expulsion case and a non-expulsion case, which is a different issue. So those are my positive submissions.
Yes.
And forgive me for being in slight disarray with the bundles. I'm afraid I've been working from 2 sets of bundles because of the pagination.
No. And you're suggesting we stop now and start again tomorrow at 10.
Yes, please.
And we'll finish by 12:30.
It may be that having had an opportunity to review the question of the respondent's notice, that I can either refine or take a different position, but I need to discuss that with my instructing solicitor.
Good. Thank you very much.